We'll hear from the appellant when you're ready.
I'm Tom Potterworth for the Williamson County and Nashville Bar, and I represent the appellant in this case, the appellants, who are presently Miss Rose and Miss Locke. They are issue of the Reverend Hillary W. Key, whose will is...
Do you want to reserve any time for rebuttal?
I'm sorry?
Do you want to reserve any time for rebuttal?
I do, Your Honor. I'd like to have 4 minutes.
4 minutes. Thank you.
This is an appeal on the construction of the will of Dr. Hillary W. Key, who died in 1912. It's also the interpretation of statutes involved and also the other issues of law. It comes before this court de novo with no presumption of correctness, and therefore the court is free to do whatever you want to do in the construction of this will. There's a lot of issues. I'm going to try to hit the big ones. The first one that I wanted to address was the substitution of Miss Locke and Miss Rose as the parties in this case for Reverend Vernon White, who died. There was an objection to that we didn't properly have them admitted, and so I want to just say I think we did, and that we followed the rules necessary for them to be admitted as the parties in the case. They were parties in the trial court, 32 parties in the trial court. Now, Dr. Key's will boils down to Section 6 that has to do with his farm in Tipton County and how he made provision for that farm passed down through the years to his family. He left a life estate to his children, of which there were 3, a life estate to his grandchildren, of which there were 16, and a life estate and the remainder interest to his great-grandchildren, of which there were 32. The last grandchild died in 1992. So it wasn't until that time that the great-grandchildren took over the operation of the farm. The farm stayed in operation below those many years, and then after the great-grandchildren took over, they formed an operating committee of which Reverend White was the chief manager of the farm. They filed a lawsuit in 1998. Mr. Walter Tipton of Tipton County filed a declaratory judgment suit for them because of the language in the will to make certain, and so they would understand who was going to inherit the farm from that point on. The crucial words to me in the will are, and from there as the law directs, after he had vested legal title in the great-grandchildren. Chancellor Brassfield took the first stab at making the interpretation of the will, and in my view, she was on the right track. She ruled that the children had a life estate, grandchildren had a life estate, and the great-grandchildren, it vested in them. But in the first order that she entered, she said that the will violated the statutory rule against perpetuities, and therefore he died intestate. And Reverend White appealed that pro se to the court. The court said that she had not considered this new statutory rule against perpetuities, and remanded back, vacated the trial court order, and asked her to start again. She came back the second time and said it did not violate the statutory rule against perpetuities, and it would go forward. She then interpreted the will to say that the great-grandchildren had inherited their interest, or was devised their interest, individually per stirpes, not as a group, but they took it individually. so that they all had their own interest in their own right. She then got to a point in her order where she had said, but it's going to be very difficult to go on from here and make a determination about what from there as the law direct means.
Counsel, I mean, your time is limited here. Let me ask you to get to an address. Why doesn't the 2005 opinion of this court as to whether or not it's per stirpes or whatever, why does that not control?
Well, there was two more orders, another order, and then the order of this court of 2005.
My question to you, though, this trial court determined, didn't it, in the 2005 opinion written by Judge Kirby, that it was per stirpes?
I can jump ahead to that, Carolyn. This court sustained the decision of Chancellor Brassfield's 2004 order. The 2004 order said that the great-grandchildren took it per capita, took it per stirpes as how they were to go on from there. The problem then comes to the next stage of the will, which is, and from there
Well,
is the law directs.
but my question is, if this court in that opinion determined that they take it per stirpes, you're now asking us to hold otherwise, aren't you?
No, I'm not.
Explain that to me.
I'm asking the court, what this court did in 2005 was to interpret the intestate statute, 312-104B1, as the applicable controlling dispository part of the law. This court, with all due respect to this court, misinterpreted that statute.
Well, maybe so. But, I mean, that's still the opinion of the court, and that was the last opinion. The Supreme Court didn't take it.
That's correct.
So maybe we made a mistake. But whatever we did, isn't that, are you asking us to reverse what that decision was back in 2005?
If in fact, how you interpret per stirpes, if per stirpes means you start with the great-grandchildren, 32 great-grandchildren, and you go from there, then that is the correct interpretation of the will. Unfortunately, in the trial court, Chancellor Cole interpreted that to go back to Dr. Key and start with Dr. Key and start with a third, and come forward per stirpes.
But did the trial court affirm, or excuse me, did this court in 2005 affirm the trial court?
Not Chancellor Cole. They did, but still the interpretation was, what did Chancellor Brassfield mean when she said they took it individual or per stirpes individually? What did that mean? Where did you start the per stirpes application? We say you start the per stirpes application with the great-grandchildren and you go forward. Unfortunately, Chancellor Brassfield had to recuse herself, Chancellor Cole took over, and Chancellor Cole's view, you interpret that by going back to Dr. Hillary W. Key, and you start with a third. It
So-
makes a tremendous difference.
So let me
in
ask
the
you a
district.
question then. Let me see if I understand what you're saying.
Okay.
You're saying the 2005 case is correctly decided if per stirpes begins with the great-grandchildren and moves into the future from there.
That's correct.
And your argument is that per stirpes should begin only at that level and should not have begun at the first level of the descent.
That's correct.
All right.
And that is the correct, in my view, the correct interpretation of 312-104B1 of how you apply that statute. That's the way Pritchard applies it, is you start with the level of the kinsmanship to the testator that are all of the same degree of kin. If they're all of the same degree of kin, they take equally. That's what the great-grandchildren are. They're all of the same degree of kin to Dr. Key. So you start there. Then that statute says, but if they're not all of the same degree of kin, from there, you take those who are more remote degree, and then they take per stirpes from there. With all due respect to this court and the 2005 opinion, that's not what the court interpreted. The court misinterpreted the statute. I think I know why. I figured it out by reading the opinion, because in the opinion, they started one generation back. Instead of starting with the great-grandchildren, they started with the grandchildren. And that makes a big difference then how you go forward from there. And that's a mistake. That's the mistake this court made.
Wherever they started, aren't we stuck with that?
I don't think so, Your Honor. I think you have I think that the interpretation is how this court interprets that. If the court interprets that you start with the great-grandchildren.
But as I understood it, you said they interpreted it wrongly. But they interpreted it.
I think they did, but the interpretation is incorrect.
Okay. In your brief, as I recall, you primarily, as I understood it, you primarily argued as to the 2000 opinion that it was a nullity because the court never had jurisdiction.
I question whether or not this court had jurisdiction, because those orders from the trial court were not declared to be final orders. So if they weren't final orders.
You questioned it because you cited I think a 1974 Supreme Court opinion that said when the facts are.
That's later on, yes, Your Honor. That is a case of Lever versus McBride.
Yes.
Which says that if it's a question of law, an interpretation of will, then it goes to the Supreme Court. And this court
that case was decided before the statute amended, wasn't it?
After the statute was.
No, it was decided before the statute.
Before the statute was changed,
And
yes.
so the statute was amended, which might explain why that case was never cited for that proposition.
Maybe, yes. We don't know.
Well, the statute was amended that opinion relied on. You've used your time. You have your time for rebuttal.
Thank you.
Yes, sir. We'll hear from Appellee. Is there more than one argument?
I was going to explain that, Your Honor.
Okay.
If the court please, the gentleman at the end is my associate and youngest son. He wrote the brief. He will not be arguing. Mr. Branch represents different parties. I will be using 10 minutes of our time, and Mr. Branch will use 5
All right.
minutes of our 15 minutes.
10 for you.
Yes, sir. And Mr. Monroe's not arguing.
That'll be fine. So
No, he would love to.
you get credit for anything that was good in the brief, and blame lies elsewhere for whatever else happened.
That's exactly what he was told by Judge Stafford the last time we were both here. And perhaps Judge Golden.
Yeah. You understand I have two sons who are lawyers, so I understand how they feel. They always operate.
Yes, sir. I have one who is a lawyer and one who wanted nothing to do with the family business, so.
But neither one of them do my family with me
Well,
as far as practicing law, but go ahead.
thank you, Your Honor. And Justice Judge Golden, congratulations on your retirement. I was not aware of that until today. Hope you take a peaceful rest from us. Good morning. My name is Marty Kaufman. I'm with the law firm of Kaufman Monroe. And in this matter, I represent Carolyn Fields Hayes and Fred Fields. They are brothers. They're not brothers. They are brother and sister and descendants of Dr. Key, and they're actually present in the courtroom today. I wanted to give the court a little bit of perspective on this case. I didn't get involved in this case till 2021. Dr. Key died in 1912. That was 112 years ago. Giving this perspective because it is preposterous that we are still here and that this money has not been distributed to these heirs that are dying on a daily basis almost. 112 years ago, this gentleman died. In the year he died, the Titanic sunk. Fenway Park had its opening game, and sliced bread was still 16 years away from its creation. That's how long it's been since this gentleman died. First complaint in this case was filed in 1988, which was 26 years ago. That was a declaratory judgment action to determine what the language in the will meant. The language that said, my children get a life estate, my grandchildren get a life estate, and the remainder as the law directs. That is the only thing that Mr. Bottorff has said that I agree with, and that is the citation directly from the will. 13 years ago, Mr. Bottorff filed a petition to partition because the real property was a working farm. That was 13 years ago. This case is now before your tribunal for the third time. Chancellor Brassfield issued an order in 2001 and 2004. Holly Kirby, and I want to address the question just to clear up. Is your name pronounced Sweeney?
Swinny.
Sweeney.
That's all right. I acknowledge most
It's tricky
pronunciations
with the
of it, so.
one N and the one I. I wasn't quite sure how to say
Yes.
it.
Think of it as the old bicycle, Schwinn,
Very well.
Swinny.
I'll try not to call you Justice Schwinn now, but
That's all right.
thank you, Your Honor. Then Chancellor Cole in 2021, Chancellor Cole in 2022, and Chancellor Cole again in 2022 said this proceeds from this farm are to be divided per stirpes. He was basing that on his own interpretation of the law, and here is what Chief Justice Holly Kirby said in 2005, which contradicts what Mr. Bottorff just argued to you. She said, he is asking this court to accept a hybrid distribution of these funds. And here's what Justice Kirby said. The statute states on its face that when the decedent dies with issues of unequal kinship, as in the instant case, the estate should be distributed by representation, which refers to a per stirpes distribution. Therefore, the trial court's construction of the language in Dr. Key's will is consistent with the plain language of TCA 31-2-104. And that is exactly what you were asking him, and that is exactly what she said. In his brief, he cites no contrary law to that. Standing here before you, he cited no contrary law to that. Aside from the fact that that is, in my humble opinion, the correct law under the law of the case doctrine, which this court is well aware of, especially in light of your comments, Justice Sweeney.
Judge.
Did I get it?
No, yeah, you did, but let's go with judge instead
Oh,
of
Judge,
justice.
thank you, sir.
I don't want to be demoted.
Okay. It's uncontroverted that these proceeds are to be divided per stirpes. In the trial court, since I have been involved since 2021, I have written somewhere between 5 and 7 memorandums responding to motion after memorandum after supplemental memorandum that Mr. Bottorff keeps filing and keeps filing and keeps filing in the trial court that my clients have been paying me to respond to. And I finally, in my last one, asked Chancellor Cole for sanctions. I didn't take that lightly. I've been practicing law for 38 years. It's the third time I have ever done that. And Chancellor Cole's response to me was, I'm not going to grant it to you this time, but Mr. Bottorff, if you come before this court one more time asking me to reconsider this issue, I'm going to grant sanctions. We need to put this issue to rest. These people need, there is almost $1 million sitting in the coffers of the Tipton County Chancery Court. We are now up to 64 heirs the last time I knew, but people are born and people die. And every time we think we're at the end result, We update the schedule of the heirs, and then here we are in some court arguing about this again. This has been decided. As for the subject matter jurisdiction issue, I want to thank the court for allowing us to brief that after a reply brief. And again, Judge, I think you had it completely right. Mr. Bodorf, when he cited the Lever case, didn't take the time or attention to detail to determine if that was still good law. Of course, the legislature saw fit to change the statute, and the statute implicitly overruled Lever, which is why there are no cases overruling Lever. And clearly, the Court of Appeals has had, and we briefed that extensively. It was quite a challenge to try to find those old statutes, but I think that's all before the court. Let's see. Mr. Bodorf argues his second issue is the issue of attorney's fees. As this court is aware, when you do a petition to partition, attorney fees are allowed by statute. We had a hearing set in front of Chancellor Cole. There are 3 attorneys involved, Mr. Bodorf, myself, Mr. Branch, and a 4th, David Owen, who is appointed as the guardian ad litem for the unknown heirs. And we started the hearing. The chancellor asked us if we wanted to try to settle it. We went in the back room at the courthouse. We spent hours back there. We came out with an agreement regarding the attorney's fees, and we came out with agreement that everything should be over. That was a hard-fought agreement, and it was an ugly situation, but we came out with an agreement. Mr. Bodorf, in his issue, has 1 sentence. His issue is 1 sentence. That's how he argues it. The issue of attorney's fees is still pending before the trial court. I don't even know what to say to that. There is an order. It is called a consent order, and here's why it's a consent order. And Mr. Branch is going to talk about this in detail because this is his issue. We come out into the courtroom, we make an announcement to Chancellor Cole. I am personally questioned and say I agree. Mr. Branch agrees. Mr. Bodorf is on the record agreeing. Mr. Owen, the guardian ad litem, is on the record agreeing. The court approves us, and a transcript is taken. That is all that is necessary to uphold that order. As the court is aware, in the case of environmental abatement, would you all like the cite to that? It's in our brief. Okay. It says that an agreement that is announced in open court, that is approved by the judge, and that a transcript is made is a binding consent agreement. Mr. Bodorf is citing the Harbor case, which was not announced in open court, which was not agreed to by the attorneys, which was not approved in open court by the judge, and of which no transcript was made. That is a final order resolving this case. Mr. Bodorf, the main issue in that order, and one of the reasons we all settled on the issue of our respective attorneys' fees, is because we all agreed nobody who represented parties would appeal this case. And not only did Mr. Bodorf violate that order and come before this court and appeal this case after he agreed in open court to not do so, attached as Exhibit 1 in our brief is a letter that he sent. There were unrepresented parties. That was discussed at the time in front of Chancellor Cole, that they would have 30 days to appeal that order, unrepresented parties. Mr. Bodorf, not only did he refuse to sign the consent order, which doesn't matter, sent out a letter soliciting them as clients. And that is attached as Exhibit 1 to our brief. That was egregious behavior. We have asked for attorney's fees. We have asked that this be declared a frivolous appeal. We have set forth all the briefing that he did incorrectly. And this court should understand that when another lawyer doesn't properly brief a case and we have to spend all that time pointing it out to this court, that's time we could be spending doing something else. and not billing our clients for that. Very well. Thank you very much.
Thank you. Counsel will hear from you.
Good morning, Your Honor.
Good morning.
Your Honors, and congratulations. You know, I'd like to start by saying this. When I first got involved in this case, I believe it was 2005, there was actually a senior attorney that represented clients that I brought to the firm. I have been familiar with this family since I was 6 years old. When the first lawsuit that was filed, I was in high school. We took on, I believe, approximately 12 clients in 2005. Out of those 12 clients, only 4 of them are left. The reason why I say that and the reason why that is important is on December the 15th, 2022, we thought this case was over. I can even go further back than that when we actually had an auction and the property was sold. Mr. Bordoff and myself thought this case was over. Only semantics remained. Why are we here? The main ingredient, the main provision of that consent order that was entered with the court was the waiver of all counsel's right to appeal. That was the bedrock formation of everything that followed. Attorney's fees and appeal. Those were the 2 bedrock formations. In fact, if you look through my brief and if you also look through the transcript, the 2 things that Chancellor Cole highlights are attorney's fees and everybody is giving up their right to appeal. One of the things that Chancellor Cole noted, one of the things that Ms. Kaufman just noted, this case is being gone on for too long. My client had asked me in regards to sanctions and things of that nature. He told me, Thomas, if it delays anything or if it does anything to get anything off track, please forget about it. I did. What we relied on was each counsel's statement that they made on December 15th, 2022, where in open court, and this is important because the elements as far as whether or not this court can enforce an agreed order, all of them are present in this case. The announcement was made in open court in front of a court reporter. It's been made part of the record. It was sanctioned by the court and agreed to by all parties that were present. In the words of Chancellor Cole, the only thing that was left in drafting this order would be 2 things: pride and authorship. We never heard anything about a stark disagreement about attorney's fees after that announcement was made. We never heard anything about, oh, I'm going to take this appeal after that after that agreement was made. Everything was done, yet we are still here. And I guess the most important thing is people continue to die and money remains left in the clerk's office. There's no daylight between what happened in the estate of Jones, which is cited in my brief, and also the environmental abatement case, which is cited in Ms. Kaufman's brief. All 3 elements that I mentioned before in regards to something being said on the record and made part of the court record and sanctioned by the judge, all of that is here. There is no way under the sun, after August 15th, 2022, that money should still be left in the clerk's office. I see my time is remaining, is almost exhausted. I've only got 10 seconds left, but thank you, Your Honors.
Thank you. Hear from the appellant rebuttal. Counsel, if you would, why don't you address the consent order?
The consent order, yes, Your Honor. Ms. Hoffman has absolutely no idea how much time I spent trying to figure out whether or not that case was applicable or not. She has no idea. She says she went to the library, she did all kinds of things, dug out dust. I picked up my phone and I called the archives. I used my bar card archive to call the state archives and say, can you please give me a copy of the bill? It's one page, and you're correct. It eliminated one paragraph out of there that seems to then let this court have jurisdiction of the case. But there's no doubt. She admits there's no definite about it. Now, I agree exactly that we went before Chancellor Cole and said, you told us to go try to settle this, and we did, and we spent 2 hours. But we didn't have any details. Thomas Branch says, Your Honor, I can give you the basics. So he gave us the basics. Do you agree to that? You agree with that? But the absolute, the detail, the devil's in the details of what you're trying to put together. Guess who I got the first email from wanting to add something? Ms. Huffman wanted to add something to the agreement. In my affidavit, I have 38 emails where the quote, what was announced to the court is being changed by agreement trying to be changed. Some things we agreed to, some things we didn't. I agreed that I would not agree with what Ms. Hoffman wanted me to do. She wanted me to agree that if any of the unrepresented parties decided they wanted to appeal, that I wouldn't represent them. And the reason she wanted that is because they'd never be able to find an attorney to represent them in this case and represent their interest and take over and have the understanding of the case that I did. It was too much. But so I suggest that Your Honor read the 38 emails to my.
Let me ask you, is the consent order that was entered by the court
Yes.
any different from what was announced to the court?
The court order that was entered pretty well tracks the basic things, but you have to read it. We didn't negotiate a deal and bring it to the court. We negotiated that deal in the courtroom. Hey, I've got an idea, let's do this. I've got an idea, let's do this. Hey, Mr. Wood, would you want to do this? No, Your Honor, I don't think I need any more. We can work this out. We can agree. That's what the agreement was. When you read what was announced to the court is, we're going to work this out.
The question is, does the order that was entered follow what was agreed to in court? That's what the question.
Here's what happened there. We went from
Yes or no? Does the order?
not with my signature.
Well, we
not with-
understand it doesn't have your signature, but what the consent order that was entered by the court, is it different from what the judge asked four lawyers, if that was the agreement, and they all four, including you, said yes?
It's different in this regard. It's different in that it does not take into account the additional terms that we were going to negotiate and work out to it. It does not have that in there. But you read the transcript. The transcript is clear. We were all trying to work out an agreement. Here's the basic terms, but the details were not worked out. That they went ahead and worked out what they wanted to put in the order without including me. Didn't even tell me that they were submitting the order.
Your time's expired, counsel. We appreciate everyone's argument this morning and your briefs on this. I will say, I don't think I've ever had a case in 25-plus years that involved a will that the testator died in 1912. So
It's a first for all of us.
I expect so. Hopefully the last.
I respectfully submit that Dr. Key understood that there was going to be a long time in the future before his family got finished.
Of course, thanks to everyone.
All
Judge,
rise.
please adjourn court, or recess court till this afternoon.
This honorable court is in recess.